to reserve any time for rebuttal?
Yes, I wish to reserve 5 minutes for rebuttal.
Very good, sir. And I have the courtroom clock right here. So whenever you're ready, the panel is ready to proceed. Go ahead, sir.
Good morning, and may it please the court. I am Alexander Bumbu, counsel for the appellant, Matthew Meineke. Today, I will make 3 arguments. First, that Mr. Meineke has standing to challenge the school safety zone trespass statute for vagueness, and then that his conviction for disrupting a school function must be reversed because the trial judge gave inadequate jury instructions and because the evidence is legally insufficient to show that he had the required intent. First, Mr. Meineke has standing to challenge Section 810.09752B Florida statutes for vagueness. In my reply brief on page 11, footnote 2, I argue that Mr. Meineke has this standing because the record rejects the state's and Officer Perry's assertion that Officer Perry asked Mr. Meineke to leave before arresting him. However, I argue today that Mr. Meineke would still have standing even if Officer Perry asked him to leave. That is because, at most, Officer Perry asked him to leave. He did not order Mr. Meineke to leave the school safety zone. And those distinctions are important because in JLS v. State and Virginia v. Hicks, 2 cases that the state relies on in its attempt to strip Mr. Meineke of standing, the defendants lost their standing to challenge those statutes for vagueness because they disobeyed orders to leave their specific zones.
Mr. Palmer, can I just see if I can maybe perhaps cut to the chase?
Yes.
This case seems to me one of simple trespass. Your client was charged with trespassing near a school zone. And I know, and based on the facts, he was basically, lack of the better word, preaching to everyone. So with the fact that he was charged with trespass, let me ask you this. Doesn't the state have the right to, based on the statute, in order to protect around the area of the school zone, if there's a legitimate business in that area to make sure that the school functions, proceed properly, no disruption whatsoever? Isn't this case very simple, where you have a person who basically was disrupting the dismissal, which basically deals with the operation of the school business? Doesn't that boil down to it, regardless of speech, regardless of what it is he's saying? Isn't that what we're dealing with, a simple trespass case?
So, Your Honor, he was charged with 2 different charges, one being the trespass on the school safety zone, which means he was within 500 feet of a school without basically a legitimate business, quote unquote, and the other one being that he disrupted a school function, which is an entirely different statute, which I'll get to later. But when it comes to your question, the state does have an authority that does have an interest in protecting schools from drug dealers, gang members, and all sorts of dangerous people. But it does not have the right to do so using a vague, unconstitutionally vague, and unconstitutionally overbroad statute. Plus, as I noted in my initial brief, the state has already satisfied its interests in protecting schools from negative persons through other statutes, like the statute.
You would agree that it is important, these are all minor children, it is important to protect them from strangers, which the school administration has no knowledge of, that are on campus in the safety zone at a prescribed time. We're only talking about 2 hours a day. Your client could preach during school. This is a very limited, content neutral statute. But let me ask you this question.
Mm-hmm.
Would you agree with me that your client was a virtual stranger that day because he did not announce his presence, nor did he go and get permission to be there? Yes or no?
Well, he was, but
did the students know him?
They did not know him.
Okay, and then your client's testimony or your argument below was he had the intent to talk to each and every child about his message. Let me be very, very clear. We are not talking about the content of his message. It wouldn't matter if he was talking about Satan, talking about secular stuff, talking about Jesus as your savior. It doesn't matter. His intention was to get in each child's face to relay a message. He didn't have authorization to be there. So explain to me, if he's not there with permission and he's there causing the children to stop with a megaphone, a poster, and loud music to the point where kids are videotaping him, walking around him, stopping, what legitimate business does he have that advances the operation of the school by doing in the zone?
Yes, Your Honor. So I'll talk about the school safety zone trespass statute portion of this answer, because this answer is based on, again, two separate statutes. So first of all, the state, though it has the authority to protect students from negative persons, cannot do so by
Negative? It
destroying
doesn't say
traditional
negative
public
people.
fora.
It doesn't say negative people. You're qualifying everything. It simply says somebody that doesn't have the right to enter or remain. You're
Yes,
trying to talk about your client. You're trying to exclude your client from everybody else by using the word negative and by highlighting his message. Your client was there without authorization. Is that correct?
But he did not need specific
Is that
authorization.
correct, sir? Is that correct?
My argument is that he did not need authorization to be on a traditional public forum, which is off of school property.
It's this. Was your client not in the school safety zone at this time?
He was, but the school
Okay.
safety zone extends 500 feet beyond the bounds of the school property.
Okay.
So it's a zone that the state spoke into existence by its ipse dixit, and it virtually destroyed any traditional public fora like sidewalks that are within that zone. So the
But
school
only
property,
during certain hours of the day, correct?
it's during between 1 hour before school starts to 1 hour after school ends. That's about,
Which, if anyone who's ever driven a child to school understands the need for order and safety in drop off and pickup and the chaos that can ensue if that the procedures that the school has in place are disrupted.
yes, Your Honor, but that's relevant to
It
these.
is a safety issue, not only for the children being dropped off and the parents participating in drop off or pick up, but for cars traveling by the school, because it creates backups, traffic backups if those lines don't move properly.
Well, Your Honor, I would direct you to Officer Perry's testimony, which said that the school dismissal process is chaotic on a normal day without my client being on the sidewalk preaching.
Right, exactly.
Right.
So the last thing they need is your client out there on the sidewalk making what is already a difficult procedure worse.
And
I
Mr.
was-
Bambu,
yes.
wasn't there also evidence presented, or at least it was related to the court, that by that disruption, cars were stopped, kids were stopped, people, as Judge Kelly and Judge Sleet indicated, people were videotaping him, and it was, a lack of a better word, almost like an absolute mess in that area. And so it boils down to my first initial question, Mr. Brown. We have to stay focused on what it is your client was charged with. And I know you're trying to make this a big deal about speech. Let's just set that aside. It has nothing to do with speech. It's the fact that he was within the school, the zone itself, and his actions in terms of disrupting a normal school function and dismissal is considered to be part of the school function. That's what I want you to focus on. And it goes back to what Judge Sleet asked you earlier. If he didn't get permission from the school to do this, and because he did not get permission from the school to do that, how can you argue he had a legitimate purpose being there?
Well, my first contention, Your Honor, is that the term under the school safety zone trespass statute is that legitimate business on the school safety zone is unconstitutionally vague. But I will say that even if it is not vague, he did have a legitimate business to be on that sidewalk at that time, because engaging in expressive activities on traditional public fora is constitutionally protected. It is a legitimate business in that school safety zone because he was on that sidewalk. Now, going back to the questions and comments that I've heard about disruption, I think it's important to remember that the disruption part concerns the statute of disrupting a school function. So I think that the school safety zone trespass statute is unconstitutional, even if my client caused a disruption and is guilty under the school disruption statute. But I will go to the record, which shows that my client's preaching was not the cause of any disruption or any material disruption on that day, because again, Officer Perry testified that Principal Butts, the school principal, testified that students taking time to get out of school several minutes after the school bell rings, taking time to get to dismissal, that's normally a cause of congestion. There was testimony, again, that my client, Mr. Meineke, was arrested only 6 minutes after school got out. And then Officer Perry testified that the dismissal process is inherently chaotic. So even viewed in the light most beneficial to the state, the evidence is legally insufficient to show that my client caused a material disruption to the school function under 877.13.
Yeah, but it took 3 administrators complained about your client. That's 3 administrators. That's probably 2 that could have been somewhere else. But 3 have to go to this school safety zone that your client is only limited 2 hours a day. He has that public fora during school session. He can stand there all he wants, but he can't stand there when they're dropping off these minor kids and picking them up. It's very, very specific and very, very limited. And you also agree that the state has a right to protect children.
I would agree that they have a right to protect children, but I would respectfully disagree with your Honor's assertion that the 500-foot school safety zone is limited. It covers houses, it covers residential areas, streets, anything within 500 feet of any school in Florida.
Well, there's one thing that you're not addressing. The fact that your client can preach in that zone while school's in session. But your client decides to be there where there are the most children at a finite time that he's not supposed to be there, because according to him, he wants to stare each one of them in the face and relay this message. And again, this is not based on his message. This is based on his conduct and his presence there.
Well, the first thing I would say, Your Honor, is that even if you were 400 feet away from the school and preaching away from the school towards someone else, he'd still be guilty under this trespass.
But that's not
statute.
what he was doing.
It's a dragnet statute, and that's my
That's
contention.
not what your client was doing here. We write opinions based on the facts of the case, not hypotheticals. So go ahead.
All right, so I will move on to the next part of my argument, which is that the trial judge erred fundamentally by failing to adequately instruct the jury. Now, we know that giving inadequate jury instructions is considered a fundamental reversible error, and that includes when a trial judge fails to correctly define the mens rea. And here, the trial judge failed to instruct the jury that Section 877.13 requires a specific intent to disrupt a school function, and she failed to instruct them that it only punishes material disruption of a school function when expressive activities are involved. In LTV State, this court characterized specific intent to disrupt a school function, as an element of the offense. And so by failing to instruct the jury on that, and also failing to instruct on material disruption, the trial judge excluded elements of this offense. She committed fundamental reversible error. Now, I will clarify that the standard applicable here is the harmful error standard, but because I, being the defense counsel in the trial below, objected to these inadequate instructions. But my argument is, since that these inadequate instructions qualify as fundamental error, they also qualify for the less rigorous standard of harmful error.
And Mr. Bambu, I just want to tell you that right now you're about to encroach into your rebuttal time. You're free to go forward. If you want to save the rest for the rebuttal, we could stop right now, whatever is your pleasure.
Sure, I'd like to eat into my rebuttal time.
All right, very
To make my
good.
final affirmative argument, which is that the evidence is legally insufficient to show that Mr. Meineke had the required intent. I will divide this argument into two subparts, the reckless disregard subpart and the specific intent subpart. First, to the reckless disregard subpart. Mr. Meineke did not have reckless disregard of the effects of his actions. Now, the reason I say this is that all 5 district courts of appeal have held that the school disruption statute, section 877.13, is a specific intent statute. The state argues in its answer brief that Mr. Meineke is guilty if he either had the specific intent to disrupt the school function or if he acted with reckless disregard of the effect of his actions. And in my reply brief, I argued that the reckless disregard standard does not apply. But here I'm going to argue that even if it does, the evidence is legally insufficient to show reckless disregard. Why? Because Mr. Meineke had no reason to believe that his preaching on that sidewalk at that time would be likely to cause a material disruption to any school function. Now, when courts deal with the issue of reckless disregard, they have held that a defendant does not act with reckless disregard when he has no reason to believe that his or her conduct is likely to cause a disruption or a harm, or in this case, a material disruption. And I cited one of those cases in my reply brief on page 28, State v. Kettle, Florida Supreme Court, 2008, which held that shooting into a building was not per se evidence that the defendant had reckless disregard, because it was not sufficient to prove that the defendant had reckless disregard that his actions might harm somebody. And here, Mr. Meineke lacked any reason to believe that his preaching on that sidewalk at that time would cause a material disruption for a couple of reasons. First, there was no evidence introduced at trial which showed Mr. Meineke having a prior preaching experience on that sidewalk and at that time, which would lead him or a reasonable person to believe that his conduct would be likely to cause a material disruption. And second, the chaotic nature of the school dismissal process at Fort Myers High School. Officer Perry testified that it was very chaotic. And so the fact that Mr. Meineke was preaching on a sidewalk in an already chaotic environment, whose chaos was not his fault, and he did not cause any chaos, but he was preaching in an already chaotic environment, shows that he did not have reckless disregard, and as a matter of fact, helps his case because it shows that his preaching, yes, it was loud, it did not cause a material disruption, but his preaching was appropriate for that sidewalk at that time because there was already chaos going on around him. So, and to close out my argument, this is the second part of my final argument, which is that the evidence is legally insufficient to show that Mr. Meineke had specific intent to disrupt a school function. Now, if the reckless disregard standard, which I just talked about, does not apply, which it does not, the state had to prove that Mr. Meineke had the specific intent to disrupt a school function. And I listed several reasons in my briefs why the evidence is legally insufficient to show that, but I will harp on 2 reasons here to close out. First, the state conceded at closing argument that Mr. Meineke, quote, might have had good intent, end quote. That's trial transcript page 351. Good intent could not have referred to the bad intent of specifically intending to disrupt a school function. If the state characterized its own evidence about Mr. Meineke's intent like that, then a reasonable person viewing the same evidence in the light most beneficial to the state would have to conclude that the evidence was legally insufficient to show specific intent. Because if that's how the state's characterizing its own evidence, that's how a reasonable person, that's an inference that the reasonable person would have to make. And I will close out by saying that if the physical school fights in cases like LT v. State, TH v. State, and MS v. State were legally insufficient to show specific intent to disrupt a school function, then so is Mr. Meineke's preaching, which occurred on a public sidewalk and it lasted 6 minutes at most. If the panel has no further questions, I submit the remainder of my arguments to my brief. I reserve the remainder of my time for rebuttal, and this court must vacate both convictions. Thank you.
Mr. Bumble, regrettably, you used all the time for rebuttal, so I just wanted to let you know that, okay? Very good, sir. Mr. Tannen, the court is ready for you.
Morning, Your Honors. May it please the court, my name is Jonathan Tannen with the Attorney General's Office representing the state of Florida, and the state is requesting that the convictions be affirmed. I will address the points discussed by opposing counsel. I believe his first point, or the point whether Mr. Meinecke's conduct constituted legitimate business. In the initial brief, the appellant raised this argument, I believe, as a challenge to the trial court's decision denying his pretrial motions to dismiss, where Mr. Meinecke moved for dismissal of the case because he argued that his conduct in exercising his First Amendment rights was legitimate business as a matter of law. The standard for the denial of a motion for dismissal under Rule 3.190C4 is whether there are no material disputed facts, and the undisputed facts do not establish a prima facie case of guilt. In this case, the trial court could find, based on the state's representations and the evidence before trial, that Mr. Meinecke did not have any legitimate business at the school. His argument was that he was merely exercising his First Amendment rights, but the issue in this case, as I think the court has pointed out, and as the prosecutors pointed out in the lower court, was that Mr. Meinecke was not simply exercising his First Amendment rights, but he was doing so in a manner that disrupted the school. He showed up without any prior authorization or invitation. He showed up with a megaphone and a loudspeaker to blast music. The trial court could reasonably determine, in terms of the pretrial motion to dismiss, that his purpose for being there was that his intent was to disrupt the school and to disrupt a dismissal of the school, and that was not legitimate business. So based on that, the pretrial motions to dismiss were correctly denied. I don't believe the appellant has challenged the denial of his motion for judgment of acquittal on issue 1, or on count 1 rather, the trespassing statute, but to the extent that he is, for the same reason, there was competent substantial evidence that the jury could have used to find that he did not have any legitimate business in the school safety zone. The next issue is Mr. Meinecke's challenge to the sufficiency of the evidence as to count 2. He argues that the evidence was insufficient to show that he materially disrupted a school function and that he had the specific intent to disrupt the school function. As far as material disruption or disruption of the school function goes, the jury saw the video of Mr. Meinecke in front of the school with his megaphone and his loudspeaker blasting music. The principal of the school testified that the school pickup was delayed because parents were stopping to look at Mr. Meinecke and students were stopping to videotape him. He testified that this resulted in a slowdown of the pickup process, which I believe the school safety officer testified is chaotic under normal circumstances. And in addition, of course, the school officials had to respond to Mr. Meinecke. So the evidence that was presented at trial was sufficient for the jury to determine that Mr. Meinecke, in fact, disrupted a school function. And as far as intent, according to the case law, intent is a question to be determined from circumstantial evidence and is almost never a basis for a motion for judgment of acquittal. In this case, the jury could have inferred simply from Mr. Meinecke's conduct that his intent was to disrupt the school function. Again, he had a megaphone, he was blasting music, and the jury could reach that conclusion based on that. Additionally, in the video of Officer Perry's body camera, which was played for the jury, Officer Perry told Mr. Meinecke that he was disrupting a school function, and Mr. Meinecke brushed him off and said something to the effect of, "You don't know the law," and continued shouting at the children with the megaphone. So he was specifically informed that he was disrupting a school function, and he disregarded that. So either under a specific intent standard or a reckless disregard standard, the evidence was sufficient for the jury to return a finding of guilt on that count. And as far as the prosecutor's comment in closing arguments that Mr. Meineke had good intent, I think the prosecutor was simply stating that no one is arguing that Mr. Meineke didn't have altruistic motives or that he's a bad person or anything of that kind. But that's a separate issue from whether he had the intent required to disrupt the school function, and the evidence showed that he did. The last issue that opposing counsel addressed was the jury instructions. The decision, a trial court's decision on how to instruct the jury is reviewed for abuse of discretion. In this case, the trial court was given two proposed instructions, one by the state and one by the defense. The state's instructions on count 2 simply tracked the language of the statute and advised the jury that the state had to prove beyond a reasonable doubt that Mr. Meineke knowingly disrupted or interfered with the lawful administration of any educational institution, school board, or activity on school board property in the state. Mr. Meineke's proposed instructions were approximately 2 pages long. They were fairly confusing and involved several misstatements of law. The instructions that were proposed by the defense are on pages 825 to 827 of the record on appeal. The instructions advised the jury that Mr. Meineke's conduct caused a material disruption of classwork or administration of the school. The statute, first of all, does not say material disruption, although courts have used that phrase before. But more importantly, the statute does not say that it has to disrupt classwork or administration of the school. It says that it has to disrupt or interfere with the lawful administration or functions of an educational institution. So that instruction was inaccurate. Additionally, it instructed the jury that Mr. Meineke knowingly intended that his conduct would cause a material disruption of classwork. Knowingly intended, again, is not the standard. The statute simply says knowingly. Additionally, the standard is not whether he caused a material disruption of classwork, it's whether he disrupted the administration or functions of an educational institution. Additionally, the proposed instructions included lengthy citations to case law with parentheticals discussing the defense's interpretation of that case law. That is improper based on the authority we've cited in our brief. And additionally, under Rule 3.390A, the jury shall be instructed only on the law of the case. It's improper to instruct juries on the facts of a prior case and to ask them whether that case is comparable to this case. So for those reasons, the state would submit that the issues discussed by the defense or discussed by the appellants are without merit, and that the conviction and sentence should be affirmed. And unless the court has any questions, I will rely on the state's answer brief for any additional arguments.
I don't believe anyone has any question. Thank you, Mr. Tan.